Afternoon, everybody. I think we're in a position where we'll go ahead and get started. It looks like people are still rolling in, but let's go ahead and get started today. We're here to talk to you about the wild and exciting world of immigration and what we can expect with this incoming administration. You've probably already heard quite a bit on the news. We have some firsthand information, having talked to high-level government officials in the last few weeks, and find ourselves in a good spot to catch you up. Along the way, if you do have questions, you can feel free to send them in the chat. If I don't get them to them right away, then what we'll do is try to follow up with you afterwards to make sure that everybody's questions do end up getting answered. So with that, what I think we'll do here is we'll dive in and just start to give you kind of the lay of the land in terms of what's to be expected in the world of employment-based immigration. And we'll tell you that we're expecting a lot. And we could probably spend a seminar on each of these next 4 points. But what we'll do right now is dive in here and just tell you that we expect that it's going to become much more complex to get visas, employment-based status in the country, et cetera. We saw that with the last administration or last time we had the Trump administration, and we expect that will happen again based on the conversations we're having. International travel for people in temporary legal status could become complicated too. Harder to get visa stamps, extreme vetting, all of those types of issues are no doubt going to resurface again. And then individuals who enjoy benefits such as temporary protected status, DACA, and other humanitarian programs will probably be at some level of jeopardy here in terms of their ability to stay in the United States. And so hopefully, if you have such employees on your payrolls, then you're going to be in a position where they've already pursued asylum or something like that, so they have a secondary, more solid benefit that they are pursuing. But of course, what we're really talking today about is worksite enforcement. And so we'll spend most of our time on that subject and just let you know what we're hearing, where it looks like things are going, and hopefully not terrorize you too much, but put you in a position where you'll feel comfortable by the end where you know what you're supposed to be doing. So with that, let's talk about their enforcement strategy and just kind of give you an idea about what is going on. First of all, they say, of course, that they plan to conduct I-9 audits and impose civil fines. And the question becomes, well, how are they going to do that on a massive scale? I was having a conversation with the former head of Homeland Security Investigations. He's been talking to Tom Homan, who is the new immigration czar coming into the United States, or coming into this administration, in other words. And they're telling me that they had already kind of developed this framework under the last administration, but never really got around to it with the pandemic hitting and other such issues. It kind of complicated it for them. But the blueprint was created, and now they're dusting off that blueprint and moving forward. And what they plan to do is bring in a lot of contractors that will support them. And last time around, they got to the point where they thought, okay, we can probably do 1,500 I-9 audits per month. And the White House came back and said, not enough, quadruple it. And so they began to scramble and build a network where they thought they could do up to 6,000 audits per month. And that framework is still in place. And they're in a position where they think that they can probably begin to carry that out fairly quickly once this new administration is installed. So what does that mean for all of us? It means that no matter where we are in the country, spread among the 30 district or regional offices of Homeland Security Investigations, each will be given quotas on a monthly basis, and they will have to look for employers that they're supposed to go after. What kind of employers will they be going after? Well, always at the top of the list are employers that they deem to be critical infrastructure. As you can imagine, some of those are fairly obvious, such as airports, etc. But in our conversations with them, as they rattled off the list of possible targets, they named hospitals, medical clinics, etc. too, as part of the critical infrastructure of the United States. Hence the reason we're talking to this healthcare group today about this issue. So they will continue to use the focus of joint employment. If any of you are relying very heavily on temporary labor through staffing agencies, or if you're using independent contract labor for janitorial services or other such things, that's an issue that you may want to explore in a little more detail. They are becoming increasingly bothered at Homeland Security about this idea that people are using contractors as a shield to employ undocumented workers. And what we've been seeing over the past little while is this task force approach. Homeland Security serves as the quarterback of these task forces, and then they'll send in either a state or federal agency to start interviewing people, such as Wage and Hour. And Wage and Hour comes in, they start asking questions such as, who sets your schedule? Whose tools are you using? Etc. And get to the point where they feel like they can establish joint employment. And then, of course, thereafter, in comes Homeland Security investigations. So you will no doubt see much of that going on. And I don't mean to terrorize too much, but one part of the conversation that I had recently was that the goal will be in every I-9 audit, every enforcement action, to try to bring criminal charges if they believe that there's a viable ground to do so. And so we'll talk about that, what that means, who would be at risk, and what kinds of activity would rise to the level of potential criminality as we go today. So a lot of people are worried in particular about the raids. I've got a picture of a Black Hawk helicopter there. The reason for that is that we went through a raid a few years back, not me and our firm, but we had a client that did, and it was the shock and awe approach, more than you would ever imagine, right? It was a company, small company here in the Denver area, and they had 100 employees. And ICE at the time, Immigration and Customs Enforcement, brought in 95 agents and had a Black Hawk helicopter hovering overhead. Well, that was a little over the top. I think all of us agreed that that was probably a little much, almost a 1-for-1 ratio in this raid. But afterwards, as I was talking to the agents, they kind of laughed and said, well, we treated it as a training exercise. That was the real purpose of all of this. I don't think we thought it was quite as funny as they did. And certainly it wasn't funny to our client, who had been on the state and national news as a result of such an astonishing raid. The last big raids were really conducted in 2018, and things have been quiet on the home front since, because the Biden administration, the pandemic, and then the Biden administration came in, and it kind of slowed everything down. But everything we're hearing is that the raids will be the way to go. And so what leads to a raid? Well, sometimes they'll infiltrate the workforce, and they just conduct an investigation where they're one of the employees, and they start asking who's potentially unlawfully in the country, etc. Sometimes it's a tip from the disgruntled worker or a competitor who feels that you're not playing by the rules or your contractors aren't. Sometimes it's that they're doing the I-9 audit and it reveals that there's an inordinate amount of fake documents. Or sometimes it's another agency's already taken a look at you. Social Security Administration, for example, maybe saying, hey, they got a lot of mismatching Social Security numbers over there. Or the Affordable Care Act folks may say, wow, problems with Social Security numbers matching up here too. So again, we don't want to be overly alarming here today, but we do want to prepare you for the worst and then give you the tools to help you get ready for it. How do you prepare for a raid? Well, step number one is you got to make sure your I-9s are in good order. Now is the time, if there ever was one, to make sure that your I-9s are in good order. If you're a company that keeps copies of documentation, and we would encourage you to do so, then that is something that can be used, especially with outsiders who may have some expertise in this area and can look at a fake document and tell you that's fake with relative ease. Ensure that your staff is properly trained and supervised on how to complete the I-9 processes. Time to enroll in E-Verify. If you haven't enrolled in it already, that is a great way to show good faith as a company. And prepare to address any public relations issues that could result from such activity. So, with that background, let's talk about how they create this. Again, I told you the focus is to prosecute individuals and the entities themselves. And the goal, that's going to be the goal in every enforcement action. One way to do that is to get employees to flip. And the government has tools to do so. They can offer such as deferred action for labor exploitation, the DALE program, and other such visa categories such as the U or T visas, where if somebody cooperates in investigations, they get legal status in this country. And of course, if they don't have criminality, still hope to be able to pursue civil penalties against employers. So let's take a step back and talk about the I-9 in a little more detail here for a bit to make sure that we've got some practical takeaways in this conversation today. Well, and before I get there, let's talk about how there are two very interested federal agencies when it comes to Forms I-9. One is Homeland Security Investigations. They're interested in you if they find out that you're not completing I-9s correctly, if you're not doing them on time, if you have missing I-9s, or if you have issues with undocumented workers. So what do they expect on the Homeland Security Investigations side? Well, they want a properly and timely completed Form I-9. They want you to have a good faith belief that the new hire you're bringing on is eligible to work legally in the United States. They want you to have a good faith belief that your current employees continue to be employment authorized. And then if you're enrolled in E-Verify, of course, they want you to make sure that you're using E-Verify correctly. We will talk about each of those bullets in much more detail as we go. But note that electronic I-9s will be a focus in the upcoming administration. They are particularly interested in this subject because they're finding that a lot of the electronic I-9 vendors out there are not fully compliant, maybe don't have the appropriate audit trails or the correct attestation or signature requirements under the regulations. So again, we'll talk about that as we go. And as you know, there has been this option for the last little while to have remote workers and then to complete I-9s for remote workers. Not going to be very common in the healthcare industry, so we won't spend a whole lot of time on that. But they're looking at discontinuing that altogether. They just are not big fans of this remote I-9 process. Now, who's the other interested federal agency? It's the Department of Justice, Immigrant and Employee Rights. They're part of the Civil Rights Division at the Department of Justice. And they're, of course, interested in employers who go too far in all of this. So we need to be careful not to panic and take things too far. So, for example, they're not interested in, or they're worried about people who engage in national origin, citizenship status, immigration status discrimination. Obviously, we can't discriminate. We've been taught that all our lives, and that is clearly true in this context. And of course, they don't want you engaging in unfair documentary practices or document abuse. And so as we review the I-9 in just a minute, we'll kind of talk about that in more detail about where employers go wrong and how that can blow up for them. So here's the I-9 in all of its glory. Recognize it's kind of small on your screens. It's small on mine here too, but we've probably all seen it enough that we have a general feel for it. I'm not going to spend a ton of time on this, but I'd like to spend just a minute to talk about what is expected on the Form I-9. So let's go through a scenario where you have terrible judgment and you decide you're going to hire me to be your new employee. So you say, Chris, you're hired. And I say, wonderful, I accept. Now, as soon as I accept your offer of employment, it's fair game to have me complete the Form I-9 all the way up until the first day of my paid employment we have for me to complete Section 1. So, for example, if you were to hire me today and then have plans to begin my employment on February 1st, that would be completely acceptable to send me either electronically, if you're using an electronic I-9, or through other means, documentation to me or as the employee so that I can complete Section 1. So let's say, to keep it simple, that we're doing it in paper format and that we're just going to be doing this on my first day of employment with you. So you meet with me, you hand me the I-9, you hand me the list of acceptable documents, and you say, here's the I-9, fill it in. Great. So I'm going to go ahead and give you my last name and my first name, the middle initial here. I don't have any other names, so I can leave that blank, or I can put NA. Some people think it's required to put the NA there. It's not. We can leave it blank in that situation. I then give my residential address, not a post office box, of course, and then my date of birth. And then if I am enrolled in E-Verify, or you as a company are enrolled in E-Verify, then I need to give you my social security number. Strangely enough, if you're not enrolled in E-Verify, I am not required to do that. So let's just go ahead and assume, though, that I'm a team player, so I'm going to give you my social security number. And then it asks for my email address and my telephone number. Of course, I can give you that information too. And it is not required, however. So if you start auditing your I-9s and you see that people maybe didn't give you the email address or telephone number, or they didn't give you the social security number before you enrolled in E-Verify, you don't have to ask for that information. But all the other information there is required. And then we have this bold language here where we say, I attest under penalty of perjury. And let's see if we can bring it up so it's a little bigger for us. It says, I'm aware the federal law provides for imprisonment and or fines for false statements or the use of fake documents in connection with the completion of this form. And I attest under penalty of perjury that I am one of four things. I'm either a citizen of the United States, a non-citizen national, a lawful permanent resident, or an individual who is authorized to work legally in the United States in a temporary status. In this case, I do happen to be a citizen of the United States, so I'd go ahead and check that box. I would sign it, and then I'd date it, and we have the perfect Section 1. So as you look at that, you think, well, that can't be that hard. But as all of us know on this call, it is that hard. People get it wrong again and again. And so the question becomes, well, what can we do if we discover that there are errors? Let's, in fact, assume that I made 3 critical errors. In the world of I-9 compliance, there are 2 types of errors. There are technical errors. Those are not initially finable offenses. In fact, Homeland Security needs to give you 10 days in which to correct them if such errors are detected. And then there are substantive errors, which are immediately finable. And so our goal, of course, above everything, is to be looking for substantive errors. But a technical error, for example, would be, suppose that I reversed, put my first name under the last name and my last name under the first name. Well, that's a technical error, not immediately finable, but it'd be something we'd want to have corrected. So let's assume that I made that mistake. And then let's assume I made 2 more mistakes, 3 more. Let's say that I forgot to check a box in Section 1 relating to my immigration status in this country, that I failed to sign it, and that I failed to date it. Well, those 3, each of those would be substantive errors, finable by up to $2,700 per count. And if I happen to be in the country unlawfully, they double to $5,400. I misspoke there. I said per count. That means per defective I-9. So it's only per I-9, but as you can see, those dollar figures can start to add up. So what do? Well, you would approach me at this point because only the employee can make corrections in Section 1, nobody else. And you'd say, Chris, you made a mistake. In fact, you made 4 here. Could you make some corrections for us? I'd say, sure. Sorry, first day of employment, I was nervous. What do I have to do? Well, let's start with having you fix the way you reverse the names, last name and first name. Okay, what do? Just draw an arrow from one to the other and from the other to the other, and then date and initial that correction. Done. I can do that. We've now fixed that technical error, but we still have 3 substantive errors here. So what else do I need to do? I need to check a box. Okay, I recognize I'm doing this under penalty of perjury. I see I failed to do that. I will now check the box. In this case, again, under this example, I'm a U.S. citizen, so I'm going to check that box, and I'm going to date and initial that correction. Then I'm going to sign it where I failed to sign, date and initial that. And I can even say this is 6 months down the road. I can even go back to today, January 9th, where I would go ahead and insert the date where I did most of Section 1 and went through this process with you. And I can put January 9, 2025. And then, of course, to the side, I'm going to date with the date on which I'm making the correction and initial that correction. And by taking those steps, we have resolved that one technical error and the 3 substantive errors and no longer are subject to fines. So it really is that easy for us to clean this stuff up. Sometimes employers ask me, well, does it really matter? Does it make a difference? Let me tell you that it really does. I'm thinking about one company out of Orange County a few years back. They came to me and said, Chris, we've got a problem. We're missing half of our I-9s and the other half are in terrible shape. What do we do? So we kind of went through this process that I'm talking to you about right now, where they went through and cleaned everything up, trained their team, everybody cleaned things up. And then, believe it or not, after we went through this for several months, about a month later, Homeland Security investigations showed up with their subpoenas wanting to see the company's I-9s. I remember talking to the agent that afternoon and telling him, you're going to find a lot of mistakes there, but we have been trying to clean this stuff up over the last few months, and we've done everything we could in good faith to clean this stuff up. All said and done, because the employer had done this cleanup effort before HSI showed up on the scene, they were in a position where they walked away with a warning notice and no fines were ever imposed. So it makes a big difference. Obviously, if you try to find religion after you receive a subpoena, they give you 3 days in which to produce the documentation. That's too late. And in fact, they take offense over that in many cases. So just remember, you want to clean this stuff up before they show up. And based on what we're sharing with you, with the astronomical numbers that are coming, your odds of getting hit with an I-9 audit are not small anymore. There's a reasonable chance that you could get hit. So now's the time to clean things up. So remember, Section 1 needs to be completed after the employee accepts the offer of employment, but no later than the first day of the employee's first day of paid employment. Okay? So we've done Section 1. Let's go to Section 2. Under Section 2, I have to establish 2 things with you. The first thing I have to establish is my identity, and the second thing I have to establish is my employment eligibility. Well, I can do that with a List A document. A List A document, such as a U.S. passport, would certainly substantiate that. It shows you my identity, also establishes that I'm a U.S. citizen, and so it helps us accomplish a great deal. But the employee is the one who gets to choose from the list of acceptable documentation what is being produced. If you tell me what I have to produce, then you're going to find yourself in a situation where you're engaging in unfair documentary practices and the Department of Justice would be coming after you. So that's one option. Another option is I could give you a List B document, say a driver's license, shows my identity, and a List C document, an unrestricted Social Security card, and that substantiates my employment authorization, and those 2 documents in combination also establish my employment eligibility. So let's go with that example. Let's have me give a driver's license. You would go ahead and insert the document title. I'm in Colorado, so we'll call it a Colorado driver's license. Issuing authority, Colorado. The state is good enough in this context. And then we're going to give you the document number on it and the expiration date. And we've got the proper List B information filled out. On the Social Security card, I'm going to give you a Social Security card. The issuing authority is always SSA, Social Security Administration. I know some of you are saying, well, Health and Human Services also issues them. That's true, but eventually it's always SSA is the position that Homeland Security takes. You could put Homeland or Health and Human Services if you wanted, but SSA will never be an incorrect answer. And then you would go ahead and insert the Social Security number. You will see that some unrestricted Social Security cards do not have or do have dates in the bottom right corner, but those are the dates on which the card was issued, not an expiration date. There's never an expiration date on a Social Security card. So you would just go ahead and put NA or leave it blank on the date of expiration. And then we go down below and you need to fill in my first day of paid employment. And now it's time for you to make attestations. And you have to attest under penalty of perjury. But there is another felony statute. It's called the Visa Fraud Statute, which also talks about I-9s. So you hereby attest under penalty of perjury and visa fraud that you, number one, have examined the documentation that I presented to you. And if you're not using the alternative procedure, which I'll talk about in a second, but this is an in-person scenario, then you need to physically review that documentation in the presence of the employee. Can't rely on a photocopy, nothing of that sort. You've got to be looking at the original documentation with the employee. Number two, that the above documentation appears to be genuine and to relate to the employee. So we'll talk about how to detect fake documents in a little bit, but also it needs to relate to the employee. It's difficult, right? People gain weight, we lose weight, we look different over time, but it's a reasonableness standard. Take a look and see whether it reasonably appears to relate to the individual presenting it. And then, to the best of your knowledge, this person's authorized to work legally in the United States. If that's all true, then you go ahead and put your last name, your first name, and your title. You sign it, you date it, and you insert the employer's information below, and you've got the perfect Section 2. Section 2 must be completed no later than 3 days following the first day of paid employment. They've recently changed that to clarify 3 business days. So if, for example, you hired me on Monday, then by end of business on Thursday, we need to have completed Section 2 together. On the other hand, if you hired me on Monday and Wednesday was July 4th, then you've got until end of business on Friday to complete Section 2. And then you go ahead and sign a date, and we've got all the rest of that done. Now, I've seen that we've had a couple questions pop up here. I was going to go ahead and bring those up, but now they've suddenly disappeared from me. So I need to figure out where they are. How do you recommend correcting an electronic Form I-9 is one of the questions. That's a good one. And it's one that we'll talk about a little more, but there are layers of quality out there in the world of electronic I-9s. There are some vendors, for example, that have such elegant systems where the person just would go ahead, say I made a mistake in Section 1, the employee goes ahead and puts in the password, gets into Section 1, makes the corrections. The corrections are tracked by audit trails, and in fact, it will even superimpose the corrections that were made and cross out the error. Obviously, lovely. Most of the electronic versions out there don't do that. In that situation, what you'd probably have to do then is print it out, have the employee manually make those corrections, and then re-upload it into the system. Let's take a look at the next one. Are you recommending we enroll in E-Verify even in states where it is not required? Yes, I am. That is where we are at this point. I didn't do that in the past, but times have changed. You need to be able to show good faith as an organization. The best way to do it is to be enrolled in E-Verify. It's a tool that's not mandatory in at least many of the states, all but 9. But it's something that shows good faith, and we want you to be able to show that. Next here is just questions can be asked in the chat area. So I think we're good there. But let's take a step back now and talk about when Section 3, that's what it was formerly known as, or Supplement B, comes into account. As you remember, in Section 1, I had 4 options as the employee, right? I could tell you that I was a citizen, a non-citizen national, lawful permanent resident, or a person with a non-citizen who's got employment authorization in the United States. Okay. Now, if anybody checks the first 3 boxes, those people do not need to be re-verified. If I give you a US passport and it expires tomorrow, I'm still a citizen of the United States. You don't need to re-verify me. On the other hand, if I were to give you, say I check box 3, that I'm a lawful permanent resident, and say that expires tomorrow, I'm still a permanent resident of the United States. If it expires tomorrow, doesn't matter. I'm still a permanent resident and I have ongoing employment authorization. Where this issue arises is if I check box 4 as a non-citizen with temporary employment authorization. In that situation, such as somebody that you may have sponsored, bringing them on an H-1B or something along those lines, or it's a situation where somebody has an employment authorization card because they're applying through some other means, family-based or what have you, then those are people that we do need to track. So let's say that I give you an employment authorization card. I check box 4 and I give you the expiration date. And let's say that expiration date is December 1st of this year. Well, when December 1st rolls around, you need to be following up with me so that you can do a Supplement B update, which is now here. So this Supplement B really serves three purposes. One is to re-verify somebody. That is the most important purpose. The second is if we're rehiring somebody. I'll hit that one in a second. And the third is if somebody has a name change. Nice way to track name changes also. So again, in this situation, you're going to go ahead and put my last name at the top, my first name, and my middle initial. And then you have the option here of confirming that I have continuing employment authorization if I check the fourth box. So let's say I did, and you meet with me and I say, oh, well, in the interim, I became a permanent resident. Here you go. And I give you my permanent resident card. You fill in that information, and then you don't have to track me anymore because now I've given you evidence of permanent employment authorization. I could also just decide to give you a List C document that shows employment authorization, such as an unrestricted Social Security card. That would also show continuing employment authorization in the United States, and you could accept that and do this Supplement B update. Now, you can use Supplement B for rehires, and I'm going to tell you that the law allows you to do two things. Either one, complete Supplement B on a rehire for anybody who was hired within the last 3 years the prior time, but it's more complex than that. If the underlying documentation expires, if there's a change in the Form I-9, etc., it can still lead to problems. So the best advice is that every time you hire somebody, you just complete a new Form I-9. Next, with regard to name changes, that is hard to track. Not everybody tells you that they're getting married, etc. Or whatever the case may be, if they're in the witness protection program or whatever the case is where people are changing their names. But as you become aware of name changes or they raise them to you, it's good to do a Supplement B update so you can put those together when it comes time to face an audit with Homeland Security. I see we have a couple more questions here. So let's take a look. Here's the next one. Should the person completing Section 2 of the I-9 and E-Verify be the same person guiding a person through completing Section 1? Not necessarily. That it would probably be a best practice to do it. You don't want to get too many chefs in the kitchen. What I worry about in a situation like that is that the person who's helping with Section 1 ends up taking photocopies or something, and then somebody completes Section 2 based on those copies. That is not permissible under the law. And in fact, HSI takes that very personally, where they would be deeply offended by the approach and find it even potentially criminal. So the best approach is just whoever's going to do Section 2, have that person do Section 1 with the individual too. But it's not required technically under the law. You could have somebody help that person on day 1, and then 2 days later or something, the employee brings in the documentation and you're meeting with that employee to complete Section 2. It would be permissible under the law. Should the person completing Section 2 of the I-9 and E-Verify be the same person guiding a person through completing Section 1? No, that doesn't matter. Section or E-Verify can be completed just based on the information that is found in Section 2. So nice thing, great question to ask. E-Verify is much more of an administrative function. It does not have all this under penalty of perjury stuff that we're dealing with Form I-9 itself. We will talk about E-Verify in more detail in a little bit. But what I can tell you is that many companies have that approach, right? One person meets with the employee, employee completes Section 1, you complete Section 2. And then we get to the point where maybe another party is looking at all the I-9s as they're rolling in and completing or running those people through E-Verify. All right, let's go on. And I just want to remind you here of the list of acceptable documents. Uh-oh, I made a mistake here. I'm just trying to make it so it's not fuzzy anymore. So again, remember when DOJ comes knocking, and they do sometimes, you want to be absolutely sure that you can say, we use the list of acceptable documents every time we meet with somebody to complete an I-9. and they choose whether they want to produce something from list A here or a combination of B and C. So make sure that you're taking that approach. By the way, it's become much more complex, as you probably know. There are now receipt notices. Sometimes those extend employment authorization cards for 540 days. It is becoming much harder to understand all of the nuances of completing I-9s these days. If you run into such issues, just shoot us a quick email and we can walk you through what you would need to do in these more unusual type scenarios. The most complicated one for me is the tribal document situation, where somebody gives you a tribal document, you actually have to go onto a government website, see if that tribe is recognized as one that immediately receives employment authorization. It's complicated. And even for us who have been doing this a long time, we sometimes have to do some digging in those situations. So we understand that a lot of this stuff is not obviously intuitive. All right, let's talk just a minute. We don't want to go too far here, but let's talk about electronic forms I-9. First of all, you've got to have system integrity. So the system must provide the same level of data integrity, security, sequence of data options on the I-9, and access to paper-based processes. Some companies get confused. They do paper I-9s and then they just upload them into their system. But if it doesn't meet all of the electronic requirements here for the electronic storage and completion of Forms I-9, then that is not a proper approach to storage. So other companies make the mistake of thinking that they can just complete an electronic I-9 and have somebody type in their name on the USCIS website. Again, not compliant. Let's go through the rest of it. Employee and employer roles. Employee completes section 1, of course, as I've told you, and only the employer can touch sections 2 and 3. Accessibility. Employers must produce electronic I-9 records within 3 business days if Homeland Security requests them. We've seen this problem with a lot of electronic vendors out there that have such complicated, convoluted processes that it becomes very difficult for them to be able to produce the I-9s in the time period that Homeland Security wants them produced. Electronic authentication, the system must capture the attestation and digital signatures to be linked to the signer's identity. We find trouble with this all the time. The regulations are very clear that the employee and the employer independently must acknowledge the attestation to which they're signing. So the most compliant programs, of course, will have a pop-up saying, I attest under penalty of perjury, blah, blah, blah. And then the person will check the box on that, I accept, and then write the electronic signature from there. If you don't have that feature, you may have a compliance issue. And I know a lot of electronic vendors, some of them household names, do not. Audit trails. It should be very clear who entered the I-9, what steps were taken, and have all of that time and date stamped. And so again, you can see why just filling one out online would not be compliant. You don't have the audit trails, you don't have the electronic authentication for the signatures, etc. Let me just see if there's another question here. If we do an audit and can't find I-9s for some employees, what is the best way to handle that? Very good question. There are two, let me start with a general premise that you should keep in mind. The first is that whenever you do have an I-9, even if it has a lot of defects on it, you should do everything you can to salvage that old I-9 and make the corrections on the I-9 itself. And of course, always ensure that they're dated and initialed. Employee touching section 1, employer touching section 2. If you're missing I-9s, or say your predecessor didn't sign section 2, those are issues that can't be remediated, right? And so in those situations, you would have to complete a new I-9 now. It's late, you didn't timely complete it, but at least you have an I-9 and you're demonstrating good faith. Better still to put a memo on the I-9 just saying, in the course of a routine audit, we discovered that we were in fact missing the I-9 for this individual. We have completed a new one to ensure that we are in compliance with applicable law. Same is true, of course, with the situation where you have a mostly completed I-9, but it wasn't signed in Section 2 by your predecessor. You go ahead and complete a new one, and then you attach the old one to the back as evidence that you tried initially, didn't get it quite right. And you probably have a memo saying that too. Don't bother doing a new I-9, of course, if the date's missing. That doesn't change anything because now it's just a late completed I-9. So that doesn't fix your situation. We see employers do that one. And there is a statute of limitations on that one. It's 5 years. So if you're going through your I-9s and you see that a lot of Section 1s were not timely completed, or they weren't completed with the date in Section 1 or Section 2, if more than 5 years has run on that specific issue, then you're not going to have a lot of reason to feel concern over it. But again, not bad to have a memo just saying, hey, we discovered this. Unfortunately, no way for us to go back in time to correct it. Can we do a new I-9 for a name change? I would say that DOJ, Immigrant and Employee Rights, would feel like that's going too far because that's requiring an employee who's already complied with the I-9 process to participate in the verification process too, producing documentation, etc. So no is the answer. I do not think that that would be an appropriate approach. Can we do a new I-9 for name changes? And there it is. I think we've got one more here. We like to see that our employee roster matches the first page of the I-9, trying to avoid any discrepancies and avoid an auditor from digging deeper. Totally agree with the approach, right? Because when you receive a notice of inspection with the subpoenas, it's going to be asking for a couple things. First, the current template of the subpoenas doesn't exactly follow the law. It's a little less or a little narrower than the law is. It says, please produce a list of all current employees. Now produce a list of all employees terminated within the last year. And now please produce sets of I-9 for each of those groups. So you're going to have to go through that process of matching everybody up with your employee roster and the I-9s anyway. If that's something you're doing already as a company, great move. We totally endorse the approach. It looks like I got another here. The employer makes a mistake in their sections. Can they correct an initial? Yes. I didn't go into a lot of detail on that, but absolutely. Say, for example, that somebody gave you a US passport and you never met with that person, but you got a copy of the document and you quickly discern that it's the Department of State that was the issuing authority, but they had left the issuing authority blank. Well, based on the copy you've got, since it's already been attested to under penalty of perjury below, all you got to do is go in and insert Department of State, issuing authority, and then date and initial that correction. Say that the date of hire is missing. Again, you can go ahead and look in the system, insert that missing information and date and initial that correction too. So the employer can make corrections to Section 2, and in fact, the employer can make all corrections in Section 2 with the exception of the signature by a predecessor. Obviously, you can't do that. That's when you complete a new I-9, as I was saying. And I think we have another here. If the employer has paper copies of I-9s to be, let me get that right, filled out by the employees, can we scan them into electronic employment records to keep as our stored I-9s, or do we need to keep paper records? Great question. The law at the outset allows you to have paper I-9s and electronic I-9s. And you can have a mix as long as there's no discriminatory approach to what you're doing. So you may do some paper I-9s because HR was out of town that day or something. And then the next week you're doing electronic I-9s. Or you may have had paper I-9s in the past. Now you have electronic I-9s and you want to move those paper I-9s into the electronic system. You're not required to do that. You could just have the paper I-9s and the electronic system. Or you could go ahead and go through a process called migration, where the paper I-9s are migrated into the electronic system. What you can't do is just put paper I-9s, upload them and put them in some kind of subfile on your computer, because that doesn't have all the integrity protections that we had talked about earlier here. So it's probably going to be on a case-by-case basis on that one. We may have to chat a little further if people are worried about that issue. All right, let's take it a step further. What I told you is that really, all said and done, only 4 things are required. You need to have, number 1, a timely and properly completed I-9. Number 2, you need to have a good faith belief that the person you're hiring is who he or she claims to be, and also is employment authorized. We had a criminal case for a while back. In fact, this was in Nashville, where a company was accepting documents with individuals who were giving correct documentation, but it wasn't theirs. So you'd have a 20-year-old handing somebody a permanent resident card for a 70-year-old. Obviously not the same person. And so make sure you are looking at both identity and employment eligibility as you go through this. But are you required to be a document expert? That's a question that we hear all the time. And the question becomes, well, maybe is the answer. You must accept documents that reasonably appear to be genuine and to relate to the person presenting them. Okay, I think that sounds fair. But what is reasonable? Well, let me tell you, for example, that if there's any kind of situation where children infiltrate a workforce, which we have seen a great deal of, more in the field of manufacturing over the last couple of years, then it's a strict liability scenario. But really, when you have an inordinate number of undocumented workers on site, or you've got a situation where it's kind of broader than that, where maybe you're allowing obviously fake documents to slip through, then it's not bad to go through a little bit of training and make sure that you've got documentation that you're accepting that is reasonably genuine. So let's take a look at some examples here. One from a recent criminal case we handled, and one from the Homeland Security template. So the one on the left, of course, is the current template from Homeland Security. And this is our buddy test specimen here. And as we look at it, you can see that the name above his name is a perfect swoosh that then goes into his birth date. And it's very smooth and kind of flows down from larger letters increasingly to small letters. On the back of this document, you can see that we're going to follow what's called the rule Charlie 194, C194. So we take a look at the C and we realize the C is smaller than the numerical digit. You see that the letters are smaller than the digits on the back side of the Form I-9. In addition, you see the 1 has a little notch at the top and then it goes straight down. There's no horizontal line underneath it. The 9 is a circle with a line going down at an angle, but it doesn't curve back upwards. And the 4 is open, not closed. So let's take a look at the one we received from Jennifer Aguilar here to the side. And the first thing I see as I look at that is, well, look at her name over the top of her photo. It's just not looking quite right, right? It's not the same flow that we have over test specimen. But then we flip it to the backside and we see the C is every bit as tall as the 1 there. So they're using the same font. The 1 does have the horizontal line at the bottom, so problematic there. The 9 starts to curve and head back upward, so that's problematic. And the 4 is closed. So she fails on all counts here. We can look at this documentation and know that Jennifer has given us a fake document. Now, we see this with other documents too. It's a little harder as you go state by state. But in Delaware, we saw a lot of fake documents coming out of Delaware this last summer. We got an identification card here. And you can see where the star is on our friend Clint's sample and the identification card. The color scheme is wrong, but maybe it's a printer, so we got to look a little deeper on that. But you can see that the star's in the wrong place. The identification card banner is in the wrong place. Delaware's cut off in spots on that card. Maybe that was a photocopy issue too. But we also see that the photo is at an angle. Well, That's not a photocopy issue. That now we got a problem. And if we want to get really carried away, on our buddy Clint's sample here, we see that under 11, he's got eyes and then B for brown. And so I think my site is too bad. That's 13. Sorry, eyes. And then B is directly below it. Okay. Whereas if we go to this over here on Francisco's, we have B a little bit to the right. It's not aligned. So looking at all of this, we can see that there's probably a problem with Francisco's documentation. And of course, I hope that there's something that's really obvious catching all of your attention, and that is this guy looks way too young. I'm looking at that picture thinking he might be 12, maybe 13. Worried about the age of this individual. Those are where cases go criminal. So we want you just to be aware that that's a very hot issue right now. If there's any possibility that younger people have infiltrated your workforce, we should probably chat. All right, so timely and properly completed I-9, good faith belief that the person we're hiring is the person he or she claims to be and is employment authorized. And then we need a continuing good faith belief. We have a duty to monitor our workforce to ensure that they continue to be employment authorized. So what are ways that companies fail here? Well, if you have an improperly or entirely missing Form I-9, then we got a problem, right? Because that, by operation of law, tells you that this person may be here unlawfully. It's not fair. But say, for example, that I'm in the country unlawfully, I've been working with you for the past few years, and you never completed an I-9 for me, by operation of law, you're deemed to know that. Same is true if I failed to check a box in Section 1. Again, by operation of law, if I'm here unlawfully, you're deemed to know that I'm here unlawfully. What about an expired temporary document? Somebody checks box 4, but you don't do the supplement B update. Again, you're now on notice that that person's potentially here unlawfully. Obviously, fake documents. We kind of talked about them. You're not required to be a document expert, but you are expected to have at least some degree of expertise. You can't just accept everything that people give you if they start to look problematic. What about confessions? We saw this with the Walmart case. That was in a contractor situation, believe it or not, where they contracted with janitorial services, and these janitorial services would come in, they'd clean Walmart stores at night. But then they started having conversations with Walmart personnel. It turned out the people having conversations were agents from Homeland Security who had infiltrated the workforce of the contractor. And the conversations were along the lines of, well, it's amazing how forgiving you guys are. I mean, you know I'm here illegally and yet you continue to allow me to work here. Well, that is not a good scenario. And all said and done, Walmart got raided twice at numerous stores and paid $11 million to get out of that fiasco. What about government notifications? Heaven help you if Homeland Security comes in and says so-and-so is here unlawfully and you continue to employ that person. But Social Security Administration, you can count on those no-match letters or mismatch letters coming in again where they say, hey, this employee has a Social Security number that does not appear to relate directly to this individual. Get those from the IRS sometimes too, etc. So again, these are scenarios that can put you on notice. Now, there's much more to the government notification piece. You don't just fire somebody if you get a Social Security Administration mismatch letter. But it does create a duty to inquire further, where you sit down with the employee, ask about it. If they insist it is a valid number, ask them to visit the local Social Security office. Give them, say, 30 days to work it out or so. And then if they haven't done anything after 30 days, now you start to have a problem. In other words, Homeland Security says it's not so much the government notification that put you on notice initially, but it's the employee's inaction that starts to put you on notice. So again, those are scenarios that get a little thorny. If you find yourself running into one of them, we're happy to walk you through it. And then E-Verify, the fourth step in all of this. Some of you are probably not enrolled in it, others are. It's not required unless you're subject to federal contracts that have FAR E-Verify clauses, or you're in a state that requires it, such as Utah and Arizona. But either way, the question becomes, well, what does E-Verify accomplish? Well, it creates a rebuttable presumption that you have a legal workforce. That's pretty good, right? If I'm an HSI office and I'm getting pressure from headquarters that I need to go audit 50 companies this month or something, well, I might be looking at companies that are not enrolled in E-Verify as a starting point. It does not, however, create a safe harbor from workplace enforcement. So keep that in mind too. It is not something that protects you. And of course, it does not take the place of completing the I-9. The I-9 is statutorily required. E-Verify is just an extra benefit that you can pursue if you want to have it. Keep in mind that E-Verify has become a tool for Immigration and Customs Enforcement and immigrant and employee rights to target employers. So if you're consistently getting it wrong, then that becomes a problem too. For example, if you're getting a number of tentative non-confirmations and you haven't followed up on getting those cleaned up, well, that becomes something that starts to hit the radar at headquarters, and you don't want that. So again, if you're going to do E-Verify, make sure you're doing it right. Why does all this matter? Well, number one, as I told you, the fines can become extreme. $2,700 per defective I-9, $5,400 if the defective I-9 relates to an employee who's here unlawfully. Knowing employment of undocumented workers can lead to a ban of engaging in federal contracts for up to a year. So that can be a big deal too. But there are criminal statutes out there too. Pattern and practice in hiring undocumented workers, it's a misdemeanor, punishable by up to 6 months in jail. But they rarely start with that one. They're looking for the felonies. So knowingly hiring 10 unauthorized workers in a 12-month period is punishable by 5 years. So that becomes a little more serious. But the favorite is the next one, harboring, well, the next two, harboring or shielding undocumented workers from detection. That can happen with the contract labor or the temp agencies. If you're not monitoring them closely enough and you're deliberately indifferent or willfully ignorant are the kinds of terms they use, then you may have a duty to inquire further about how they're running their operations, or if you're seeing those kinds of issues at your locations too. Another is encouraging or inducing somebody to remain in the country in violation of law. If you find out somebody's here unlawfully, but you continue to employ that person, you're now getting into the realm of facing up to 10 years. But it's more than that, right? Because if management in the company knows about that too, now you're getting to a point where the company itself could be subject to criminal prosecution, and if convicted, could face forfeiture of assets, meaning loss of the property, loss of disgorgement of profits, etc. This can be an end of the world kind of scenario. Of course, you can't lie on the I-9, as I told you earlier, and there are scenarios now where we're seeing human trafficking. I doubt that's common in the healthcare industry. I think you probably would know what to look for, so I'm not going to spend much time on that. But how extreme can all this get? Well, the answer is very extreme. Aspen Tree Experts is an example. They settled their case a couple years back for $95 million. $15 million of that was in civil fines. The other $80 million was in forfeitures because they had criminal issues. In fact, 3 managers were charged with some of those criminal violations we just talked about. And the allegation was that management acted with willful blindness in hiring undocumented workers. So again, we don't want to be overly alarming here, but we do want you to be aware of what's coming with this enforcement storm. I see that my time is almost out. I'll just quickly mention the IMAGE program. I'm not a huge fan of it, but it's a program where you can partner with the government, where they conduct an I-9 audit, where you're essentially immune while they do it, unless they find any kind of criminal misconduct. And then they kind of work with you to help you ensure that you have a legal workforce. It creates a degree of immunity. You're not audited for the next 4 years. So in some ways, it's very positive, but you would want to consult with your attorneys before you just dive into that. And then I think somebody just asked a question here. How does this apply to independent contractors? The answer to that is that if you are, again, going back to the task force issue that we were talking about earlier, if they can substantiate that you are jointly employing those workers, then you got an issue, right? Where both are jointly and severally liable, especially if they can show that you were deliberately indifferent to the issue. It doesn't mean that the independent contractors get off. In fact, in the Walmart case that I talked about earlier, the independent contractors were prosecuted and people went to prison. Walmart personnel did not, and they just got hit with the $11 million fine. And I think I see another. No, I think we might be good. Should travel agencies be sending us copies of the I-9? Sometimes they just send a signed attestation that they did one. Sure, I fully understand the context of that. That might be one where you just shoot me a quick email afterwards or give me a call and we can talk you through that one in a little more detail. But we are at time, everybody. So we're going to go ahead and call it at this point and thank all of you for attending. Thank you very much for coming today. And again, now's the time to make sure you're taking the appropriate steps. Thank you, everybody.